Hey guys, happy Wednesday to you. Like I'm sure Dr. Bates just said, I do have the good old case of Mount Healthy City School District Board of Education versus Doyle. It is a speech rights of public employees case, and it's kind of looking about the evidence needed to for a board not to rehire a teacher. And so, kind of some backstory on this case. It is a Supreme Court of United States case in 1977. The respondent's name is Doyle. He sued his school district for not renewing his contract and said it violated his rights under the First and 14th Amendment. His first 3 years of employment, he was on a 1-year contract. His fourth year was a 2-year contract. And there were some incidences during his fourth year that kind of got him in some hot water. Even though his fourth year, he did become like the teacher association president that was elected. But these type of dealings with negotiations and those type of things, even though there was some tense moments, really didn't play into him not being rehired. Instead, he had an argument with a teacher in which that teacher slapped him in the face, and he refused to accept his or her apology, which then resulted in 1-day suspensions for both teachers. Well, after that kind of came down, the teachers then had a good old-fashioned walkout, and both suspensions were terminated and those type of things. So really not much played out with that. He later then got in a good old argument with the employees of the school cafeteria. That's right, messing with people that make your food's never a good idea. And his argument was over the amount of spaghetti that they served him one day. But also inside the cafeteria, he had some incidences with profanity and obscene gestures to students and those type of things. But the big incident was a phone call that he placed into the radio station dealing with the principal's memorandum that was relating teacher dress and appearance to the of public support for bond issues. Right or wrong, he later apologized to the principal, saying that he really didn't have a great deal of communication understanding on the situation, but nevertheless it did go public through the radio station. About a month later, the superintendent submitted 9 names, his included, to the board for non-renewal. It was seen that he was not going to be renewed, so he came back and he asked for the reasons why, in which the superintendent said that he lacked the tact of being able to handle professional matters, but also, and he did cite that radio call into that radio station. So, and that is what the courts found to be a violation of his amendments, and that he does have the right for this free speech and those speech rights under public employees if he was tenured or not. And so they ordered that he should be reinstated with back pay. But what's interesting about this, as it kind of proceeds and goes further, that the school district didn't need any big cases or causes or reasons to not renew him because he wasn't tenured. And even though that there's one reason cited by the superintendent for not bringing him back, there is a rule of causation that really focuses solely on whether protected conduct played a part, substantial or otherwise, as it says on page 851, in a decision not to rehire could place an employee in a better position as a result of the exercise. And so it's a pretty interesting situation once you hear that just because there's a protected situation with his rights, that it's going to be weighing heavily on the minds of the people making these decisions, but they don't need that decision, in this case, the phone call to the radio station, to not renew him. And so it's a gray line, people saying, well, you were thinking about that when you decided not to rehire me. And it's kind of a murky situation. So as it goes on, the burden was placed on Doyle to show that this substantial factor was the reason for his non-renewal, which he did do that, but they ended up vacating the Court of Appeals because of that very reason, that the burden, even though carried by him, wasn't enough to say that there was plenty of other things and you were going to have a bettered situation, and both sides are going to be impacted, because if you were brought back, you were going to be tenured, and there was plenty of other reason not to restate you, and the fact that they didn't need reason to begin with. So thanks so much, you guys. Have yourself a good night. I'm going to sprinkle a little bit of cheese on this thing. I'm going to enjoy it. Thank you.